The common law question from July of 1996 is another one of the most brutal, difficult, unpleasant questions to appear on the California bar exam in the last 30 years. And the reason this fact pattern is so hard is not because it's hard to understand. It's hard because it is testing little areas of black-letter law that are far more common on the multi-state than on the essays. But when these issues are tested on the multi-state, they are much easier than they are here. Have a look at the call of the question. 1. How should the federal court rule on the following arguments of the state ex-attorney general? A. That Congress lacks authority to enact such regulatory legislation. Discuss. B. That Congress lacks authority to require the individual states to enforce the LPPA. Discuss. And C. That Congress lacks authority to regulate state and municipally owned housing through such legislation. Discuss. Well, just reading this call of the question was enough to send trembles of fear through thousands of bar applicants that summer during the California bar examination. These are issues that rarely are tested on the essays, and when they are tested all at once, and you either know it or you don't know it. Then the second call of the question, obviously more tertiary to the principal question, how should Ida's motion to intervene be decided? Discuss. Well, we'll figure out who Ida is, what her concerns are, and then we'll judge whether or not she ought to join the litigation. Now, go to the top of the question and let's carefully review it together. In paragraph 1, we find out about the LPPA, the Lead Poisoning Prevention Act. Congress seeks to limit the exposure of children to lead poisoning via this act. The LPPA requires the owners of residential housing, including state and municipal owners of public housing, built before 1965, when lead-based paint was banned, to test all dwellings for the presence of lead-based paint. The owner then has to record the results in the county recorder's office, and if lead-based paint is found, then the owner must take remedial steps to fix it at the owner's own expense. And they've got 18 months to do it. In paragraph 2, we see that the LPPA is placing requirements on the states. The states must designate an agency to enforce LPPA within each state. Plus, private enforcement is allowed under LPPA in a federal district court, and that includes injunctive actions by residents and compensatory damages actions by anyone injured by failure to comply with LPPA. How complicated and tricky. In paragraph 3, we find State X, through its Attorney General, filing suit in federal district court in State X against HUD, contending that the validity of LPPA under the Constitution is not present. Basically, they're arguing that LPPA is invalid under the Constitution. The suit alleges that Congress lacks authority, A, to enact the legislation, B, to require the individual states to enforce it, and C, to regulate state or municipally owned housing. Next, we meet Ida. She's a wealthy investor living in State X who owns no residential buildings, but claims to be planning to buy several apartment buildings built before 1965. Okay, let's stop right there. Unless Ida comes up with something a little bit more tangible than that, she lacks standing and she shouldn't be allowed to join this case. Moving on, Ida claims that LPPA imposes such extraordinary liability risks on owners as to constitute unlawful confiscation. In other words, a Fifth Amendment taking. Ida has filed a motion to intervene as an additional plaintiff in the State X Attorney General's pending suit to contest LPPA. HUD opposes Ida's motion to intervene, claiming that she lacks standing. No kidding, they're right about that. We're going to have to take the time to carefully analyze the situation. Then once again, we get the call of the question. Okay, this is actually a fairly easy question if you know the law. But the problem is, a lot of people don't know this law very well, or they only know it for multi-state purposes. Now, in my judgment, con law is the easiest subject on the multi-state because it's very hard for them to hide the ball. They've got to give you the correct pick somewhere amongst the choices. And a good application of deductive reasoning skills and some law knowledge can get you through most con law MBE questions. But here, they are not giving us the theories. We've got to come up with them, and if we don't know them, we're basically out of luck. So one of the reasons why I'm including this dreadful fact pattern in this seminar is to guarantee that you've been exposed to these issues. Study this fact pattern and study my answer, and you won't miss these issues if they come up on your exam. Once you know it, it is pretty easy. The problem is most candidates don't know this stuff very well, and this fact pattern exploits that vulnerability. So now please turn the page and have a look at the outline of issues that I've got for you, and I think you'll see that if you know what you're doing, you can organize this question fairly easily and then respond to it in a very concise, direct way. Okay, the first issue that we're talking about is the Attorney General's arguments about Congress lacking the authority to enact the legislation. Here, I think most candidates can come up with a potential Commerce Clause issue. That's the one that most people spotted. But the 10th Amendment is a little trickier, and the Necessary and Proper Clause is something that most applicants don't have at the tip of their tongue until they study this fact pattern. Next, we focus on the arguments about Congress and the authority to enforce. Here, again, the 10th Amendment is relevant and also intergovernmental immunities. Yes, those issues are on the approach to con law for a reason, and here they are. Next, we face the arguments about Congress lacking the authority to regulate state and municipally owned housing. We focus here, again, on the Commerce Clause and the 11th Amendment. So we're looking at the 10th and 11th Amendments, the Necessary and Proper Clause, intergovernmental immunities, and we are making sure that we don't panic. There's plenty to learn here. And then we focus on Ida's motion to intervene. I say she lacks standing. Game over for Ida. Okay, now let's have a look at my answer. Here I do think there are a number of paragraphs that you can learn something from, especially if you're coming into a review of this fact pattern without a really sharp knowledge of this part of the con law outline. Notice up front, in the very first paragraph I present, I lead with the facts. I explain what the LPPA is, what it does, and what the law requires. Next, I point out that the Attorney General of State X has filed this lawsuit, and we're going to review the issues presented by that case. First, Congress lacks the authority to enact the regulation. We focus on the 10th Amendment. And here, I lead with the law for a change, and I define the 10th Amendment. Specifically, it reserves to the states all powers not specifically designated to the federal government, and Congress can only act according to enumerated powers. So here the State Ex-Attorney General is arguing that LPPA is illegal and that Congress is trying to regulate for the health, safety, and general welfare of its citizens, and that that's exactly the sort of legislation that the states are responsible for, not Congress. Next, we focus on the Commerce Clause, and here the Commerce Clause is the reason why the earlier argument is likely to be rejected. The LPPA is a rational approach to dealing with a genuine problem, and the Commerce Clause is the likely reason for it to be upheld. Next, we focus on the Necessary and Proper Clause, and here Congress has authority under this part of the Constitution to enact regulations that are appropriate to ensure that the intended goals behind the legislation are achieved. So this part of the LPPA is likely to be upheld under necessary and proper authority also. Okay, that's it for the first line of arguments. Next, we turn to the arguments about Congress lacking the authority to require states to enforce the LPPA. And here, the state has a much better argument. Here we're focusing on the 10th Amendment and intergovernmental immunities. Here, even if we concede for a moment that Congress has the authority to enact the LPPA, the 10th Amendment might well prevent Congress from requiring the states to designate a state agency to enforce LPPA within that state. Here we're focusing on intergovernmental immunities. Certainly the federal government has the authority to hold benefits from states that decide not to cooperate with federal legislation. And if you're studying the news, some state responses to the No Child Left Behind Act basically amount to that. Still, LPPA is not set up in this fashion. LPPA does not penalize states for not cooperating. It just requires that states enforce it. And it's likely that intergovernmental immunity's constitutional principles will strike this provision of the LPPA. Then, finally, we confront the last arguments of the Attorney General, those dealing with Congress lacking the authority to regulate state and municipally owned housing. You'll notice up front I explain what one significant respect of a likely federal court narrowing the LPPA would confront, and that is private parties being allowed to sue states in federal courts. That's unlikely to be upheld, and we can examine why that is. First, we focus on the Commerce Clause. We consider that regulating state and municipal housing is traditionally a function of state and local governments, but the federal government has been involved in regulating federal and state-owned housing for some time under Commerce Clause authority, and in fact, some of the comparatively early civil rights cases dealt with Congress's right to order desegregation of local hotels and motels, and they were upheld under the Commerce Clause. So we turn to the 11th Amendment, and here we've got a significant problem for this federal legislation. The 11th Amendment prohibits private parties from suing a state in federal court, and the LPPA expressly allows private parties to sue property owners in federal court in order to enforce the LPPA. And here, Congress doesn't have that authority. They don't have the authority to authorize private parties to sue a state that owns housing in the LPPA. No, the 11th Amendment would not prevent private parties from going to court to enforce LPPA provisions against municipal governments, but it certainly would prevent them from suing states in federal court. Well, that's it for considering the really meaty issues of this fact pattern. And a word to the wise, it's a very advisable fact that you should understand the 10th and 11th Amendment and some understanding of intergovernmental immunities. This fact pattern proves it. Okay, now let's turn to the easy part of this fact pattern, the issues relating to Ida's motion to intervene. You'll notice up front, I lead with the facts once again. And although her claim does appear to present a Fifth Amendment taking issue, she's not the right person to be allowed to litigate it. Ida lacks standing. So look at the analysis in the paragraphs I've marked A, and you'll see again, I explain the factual situation. Here we've got a wealthy investor who doesn't even own any housing. She's just thinking about maybe getting some in the future. And that's not good enough to give her standing to join this lawsuit. So I conclude that HUD is correct, that Ida lacks standing, and that the motion to intervene should be denied. And that wraps up a consideration of yet another remarkably sadistic California bar examination con law fact pattern.